Thank you, Madam Deputy Speaker. It's a great pleasure, of course, to follow the honourable member for Chippenham speaking in such an important and very moving debate. I'd like to start, of course, by congratulating my honourable friend, the member for Thirsk and Malton, for piloting this private member's bill through the Commons with such, well, I hope it will conclude today, with such skill and with such deftness. Which, of course, is something we've come to expect from the honourable member for Thirsk and Malton. And let me also pay tribute to members of the Bill Committee who clearly improved the bill with such diligence and thoroughness. I think I sort of gather from comments made in the Chamber today that the member for North Ayrshire and Arran served on the Bill Committee, along with the honourable member for Edinburgh and for Torbay, and I think possibly from Colchester as well. So I do apologise if I've missed any Bill Committee, and the honourable member for Charnwood as well. How could I possibly forget the honourable member for Charnwood, who is certainly nothing if not unforgettable. So I thank and congratulate those honourable members for the work they've done, and the member for Torbay, who has clearly given this matter some extremely careful and diligent thought in tabling so many very detailed amendments. I'd like to talk to some of those amendments, but before doing so, I would just like to observe that these are measures which are extremely welcome, which strengthen protections and strengthen rights. And one hears occasionally people claim that, particularly as we think about leaving the European Union, there may be some sort of race to the bottom on regulation, and we somehow plan to have less stringent employment rights in this country than the rest of Europe. Well, this bill proves conclusively that is not the case, and that this Parliament is willing and is eager to legislate to strengthen employment rights and strengthen the rights our citizens enjoy in ways that go far beyond anything contemplated by European Union legislation. And this is evidence that we are doing more, not less, when it comes to employment rights and other rights. Madam Deputy Speaker, let me turn to the first group of amendments tabled by my honourable friend, the member for Torbay, Amendments 1, 2, 12 and 14, which seek to make clear that the definition of parents in this context goes beyond, or should go beyond, simply biological parents to include people who are acting as the deceased child's principal guardian. For example, Amendment 1 seeks to do that, to include grandparents, where they act as the child's principal guardian, as Amendment 2 does. I think those amendments are absolutely right in spirit. I'd be very interested to hear from the Minister when he responds, whether the Minister feels these are things that need to be on the face of the bill, as these amendments would do, or whether these are issues that can be dealt with in regulation. But whichever approach is adopted, I think the spirit and the thrust of the amendments which my honourable friend, the member for Torbay, has tabled are absolutely the right amendments, because it's quite clear that whoever is caring or was caring for the child, whether it was the biological parent or a grandparent or indeed a foster parent, they all have an equally close connection to that child and will suffer the same level of anguish as a biological parent would do. So I agree very strongly and very wholeheartedly with those amendments which my honourable friend has very wisely tabled. I will.
I thank the honourable member for giving way, and I appreciate the comments he's just made about the amendments. Would he agree with me that the focus on this has got to be that we don't end up with a scenario where a primary caregiver, someone who's been the parent in all senses of the word, can't get access leave, but in theory an estranged biological parent can then suddenly say yes and have it. That's how we want to be clear, is it must be the person who's doing the parenting and reflecting the impact it be on them.
Yes, the honourable member for Torbay puts it extremely well. He puts it far better than I did. It is, of course, right that we focus this on the person who is the primary carer, essentially whoever that might be. So I entirely agree with the intervention that my honourable friend just made, and I thank him for bringing that clarity to the comments I was making. In the same group of amendments, my honourable friend for Torbay and the honourable member for Mid Dorset and North Poole have tabled Amendment 21, which widens the age to beyond 18. And of course, the honourable member for North Ayrshire and Arran has tabled a similar amendment, number 24 and number 25. And I must say, I was undecided on the merits of these amendments, but having heard them speak, and also the honourable member for Sefton speak on this topic, I do see the force of the argument. I had initially thought that one has to draw a line somewhere with these sets of rights, and were you to include a child of any age, then you might equally say, well, why not include a deceased sibling, or indeed a deceased parent, or a deceased spouse? Because I will in just a moment. Because you might, the emotional attachment to those other relations are just, in many cases, just as strong as the other attachments we're talking about. So wherever one draws that line, there is going to be relations laying just the other side of that line with an equally strong attachment to whom the provisions don't apply. So the fact that there is a line somewhere doesn't argue for the fact there should be no line at all. The question is simply where to draw it. But I must say, I was powerfully moved by particularly the comments that my honourable friend, the member for Mid Dorset and North Poole, who I see is not currently in his place, made about his brother. So I can see there are very, very powerful arguments on both sides. And I give way.
Thank you for giving way. It's making a very good speech. But on this, does you agree with me? I mean, there have been some very powerful arguments made on both sides about the 18 threshold. Is he at least reassured, as I understand it, those over 18 would be covered by the reasonableness part?
Yes, well, I see that the honourable member for Thirsk and Malton is indicating from a sedentary position his agreement with that point, and that is certainly good enough for me. And I do take comfort from the fact that these reasonableness provisions would apply to children over the age of 18. But I think it's a very difficult question, and we've heard some very powerful commentary on it from both sides of the House. I would like to just comment, particularly since he's just returned to the Chamber, on an amendment tabled in committee and passed unanimously by the honourable member for Colchester, which extended the provisions of this bill to stillborn children born after 24 weeks of gestation, which I know is something he has had a very tragic personal experience of. I strongly welcome and support that extension, but I would, and I congratulate him for tabling the amendment, but I would just observe in passing and say to the Minister that perhaps not in this bill, but on some future occasion, we might also consider the entitlement for parental leave for those parents who have very premature children, who are lucky enough to survive. And I am one of those. My children were born at 25 weeks, my twins, 25 weeks and 1 day, which is extraordinarily premature. They were very lucky, blessed, in fact, to survive. And I think and remembering back to that neonatal intensive care unit where there were so many parents who were extremely distressed, as the Minister can imagine, whatever the precise circumstances their children were in. And I think extra parental leave for parents in those circumstances, very premature births, is something that we really should be looking at. Perhaps this bill is not the place to do it, and perhaps it's too late to introduce amendments, but I really do ask the Minister to consider that, because the experience of parents with children in a neonatal intensive care unit, of 20-something weeks gestation, very difficult for those parents. And I think we do need to give some further consideration to that. But I think the honourable member for Colchester introduced at least improves this bill in that regard. Just moving on to Amendment 7, tabled by my honourable friend, the member for Torbay, again, who has clearly been working extremely hard with these amendments. He introduces Amendment 7, which makes clear that the employee can receive additional pay from their employer that goes above and beyond the statutory minimum, but that only the statutory minimum is reimbursed by the taxpayer. I think he's made the point in interventions on the Honourable Member Sefton to say that this statutory minimum is just that, it's a minimum, it is a floor, not a ceiling. And although that is the extent of taxpayer support, of course, I'm sure honourable members on both sides of the House would very strongly encourage employers to actually reimburse employees at their full rate of employment during times where they have compassionate leave, either for this reason or indeed for any other. So I'd like any employers looking at this debate to listen carefully to that exhortation. And as someone who set up and ran businesses for 15 years before being elected, that is something that my businesses would always have done without question. Give way.
I thank the honourable member for giving way. Just to confirm that his interpretation is correct, in that my intention in bringing this amendment forward was to ensure that it was about being clear what the minimum was under the legislation, i.e. the statutory pay. But of course, it's about a floor, not a ceiling. Employers would be welcome to go far, and this bill, this amendment would not change that.
Yes, the honourable member is absolutely right, and I'm grateful for him adding that additional clarification to the point I was making. I think we're in complete agreement. And speaking of complete agreement, there is just one final point, Madam Deputy Speaker, I would like to make on these amendments, and that relates to Amendment 9, tabled once again by my honourable friend the member for Torbay, assisted on this occasion by my honourable friend the member for Mid Dorset and North Poole. Amendment 9 talks about introducing a test of reasonableness in relation to notice periods, and that is something a number of members have spoken to. Clearly, in circumstances of probably unexpected bereavement, requiring parents to comply with potentially quite prescriptive and very detailed notice periods, I think would not be appropriate. As other members have said, it introduces the risk that a parent, a bereaved parent, may inadvertently fall foul of one of those very prescriptive notice periods. So I would say that there is a very strong case for making clear, either on the face of the bill, as this amendment seeks to do, or in regulations subsequently, that there should be a general requirement for employers to act reasonably in this context. And I think that would provide just a general level of protection to bereaved parents, just in case they do inadvertently fall foul of any very prescriptive set of notice periods. So I think as a catch-all, that requirement to behave reasonably would just provide general protection and general assurance. But, Madam Deputy Speaker, I know there are other members wanting to speak to these amendments. I think this is an excellent bill. I congratulate again my honourable friend, the member for Thirsk and Malton, for bringing it, and I'm delighted to be here today in support of this excellent piece of legislation.